At the end of the Second World War, Australian National Airlines was the dominant player in the Australian aviation market. The Labor government of Prime Minister Ben Chifley was perhaps one of the most socialist-oriented governments we've had in Australia. The Chifley government's policy was to nationalise key industries, including banking and aviation. In 1945, the Parliament passed the Australian Airlines Act, which empowered the Commonwealth government to establish a new government-owned airline. The legislation provided for the airline to have a monopoly. It gave the new airline the power to compulsorily acquire aircraft and facilities. So the new government airline could potentially take their places and kick them out of their own facilities. They attacked the legislation in two ways. First, the airlines noted that Section 51(1) of the Constitution gives the Commonwealth the power to legislate with respect to trade and commerce with other countries and among the states. A&A argued that this did not extend to the power to actually participate in trade and commerce. This argument failed completely. Chief Justice Latham said, "There can be no reason in law why the power to make laws with respect to trade and commerce with other countries and among the states should not include a power to make laws enabling the Commonwealth itself or a body established by the Commonwealth to take part in such trade and commerce." The second argument was that if the Commonwealth tried to establish a monopoly for the new government airline by doing things like compulsorily acquiring planes, this would breach Section 92 of the Constitution, which states that trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Clearly, airline operations would not be free if they were prevented by a government monopoly. This argument was successful. Justice Stark said, "The Airlines Act operates to control air transport among the states and is pointed directly at that trade or business. It operates to preclude everyone engaging in that trade and business other than the Commission and its contractors, so long as adequate service is provided. In my opinion, such an enactment is obnoxious to the provisions of Section 92. As a result, the monopoly failed and A&A continued to fly until it later merged with Ansett Transport Industries to become Ansett Airlines, which remained in the sky until 2002.